Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where am I? Oh, I'm at the classroom here at GAT Guns. It's quiet now, but hey, if it's anything like last night, we're going to have a full house later tonight. That sound you hear in the background, well, that's the sound of Illinois residents exercising their freedom and liberty. God bless all of them. Listen, I say all the time that I love to take real life stories that we find in the news, and use it as teachable or learning moments. And there is a disturbing case that comes from Arkansas that, candidly, I'm not certain what the prosecuting attorney or the police officers were thinking here, but we're going to go through it with you, and we're going to use it as a teachable and learning moment. So today, from GAT Guns here in East Dundee, Illinois, let's spend a few minutes and let's talk about why is this man being charged instead of getting a medal?
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They paved the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.
Okay, America, the story we're talking about comes from Arkansas. We will link up the story down below so that you guys can all geek out on it for yourself. It is a disturbing story. It involves the suspect, Aaron Spencer, the father of the female victim here, as well as a 60-something-year-old gentleman, Michael Fossler, who is now deceased. Now, I have linked up down below both the original Fox story as well as a Facebook post from the family that goes through some more details. And there is a significant misspelling in the family's recount of the events that doesn't really change the equation here much, but I do want to point that out. Here's the disturbing details. Apparently, the deceased, Mr. Fossler, was accused of sexually assaulting Mr. Spencer's 14-year-old daughter. And not only was he accused of it, he was charged with multiple felonies. Now, there's a dispute as to how many felonies he was previously charged with. Mainstream media was reporting a couple. The mother of the victim, that is the wife now of Mr. Spencer, is claiming that it was at least a half dozen felonies. Be that as it may, also in the family's account of the events, this word was used to describe what Mr. Fossler had allegedly done to their daughter. Now, that can be interpreted a couple of different ways. It could be a misspelling of this word, which again, I am not minimizing the action whatsoever. It could also, however, be a misspelling of this word, which of course now takes the prior allegations and takes them to the most extreme and dangerous levels. Now, Mr. Fossler was charged, and since he was charged, I presume that he made an appearance in court where those charges were presented to him. He was arraigned on the charges. He was forced to enter a plea. I'm assuming his attorneys entered a not guilty plea, and then conditions of release and or bail were discussed. Why? Because that's how it always works, okay? And the conditions of release included, as it always would, a criminal no contact order, which would prohibit Mr. Fossler from having any contact whatsoever with Mr. Spencer's daughter. Okay, now what are the allegations? The allegations is that Mr. Spencer's daughter actually goes missing. No one can seem to find her. Mr. Spencer, fortunately, is able to track down his daughter. Where is she? Yeah, she is with Mr. Fossler. She is in Mr. Fossler's car. And then the allegations is, as a confrontation ensues, Mr. Spencer ends up using lethal force, and now Mr. Fossler finds himself deceased. But the story also then goes on to say that Mr. Spencer was arrested for one count of first-degree murder, which begs the question, should he have been arrested at all? And that brings us to our teachable moment here, because as we know, under most states, in most situations, you are allowed to use lethal force in one of four situations. Number one, you yourself are in imminent threat of death or serious bodily injury. Number two, somebody else in your presence is in imminent threat of death or serious bodily injury. Number three, you have a felony being committed upon your person. Or number four, you have a felony being committed inside your home. Now, here's the thing, okay? I took a look at Arkansas law, took a few notes here. A violation of a no contact order, especially this type of no contact order, when the allegations are what they were against Mr. Fossler, under Arkansas Code, Section 5-53-134, subsection B2, that is a felony. That constitutes a felony. If Mr. Fossler was violating those no contact orders, he is committing a felony, and he is committing a felony upon the young Spencer girl. And here's the other thing, because under Arkansas Code Section 5.14.127, yeah, the age of consent for anything in the state of Arkansas is 16. And let us remember that the allegations here is that Mr. Spencer's daughter is only age 14. So what we ultimately have here is we have an underage girl who has been sexually assaulted by some 60-year-old deranged pervert who then violates multiple no contact orders, kidnaps her. It is a kidnapping. Why? Because she's not old enough to consent. So now we have another felony being committed against the person. So at this point, we have multiple felonies being committed against their person in a situation in which this person has already committed felonies against her person. Is there a reasonable belief that she is in imminent threat of death or serious bodily injury? And then let's go back to the original allegations, because under the original allegations, according to what the family is saying, the only evidence that would have ever been able to prove Mr. Fossler guilty of these crimes would have been the testimony of the young Spencer girl. Therefore, getting rid of her would have in all likelihood precluded the ability for him to be prosecuted. So, with that in mind, is there any doubt that this young woman was in imminent threat of death or serious bodily injury at the time that her father found her? Absolutely, positively not. And for that reason, Mr. Spencer is lawfully allowed to use lethal force in defense of his daughter and does so accordingly. The fact that there was a struggle or some type of confrontation may only further justify Mr. Spencer's action. But as far as we break it down here at Washington gun law, we see no reason under the sun, especially in a state like Arkansas, where Mr. Spencer was not absolutely positively lawfully allowed to use lethal force. Listen, we're going to go ahead and link up both the story down below as well as the Facebook post so you guys can judge for yourself. And then let us know in the description box, what do you think? Listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, click on that link right there. Let us know. It's probably going to be better than anything we come up with. If you want to subscribe to our monthly newsletter, the information on how to do that is all down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From GAT Guns here in East Dundee, Illinois, thanks for watching. Stay safe.